The defense attorney calls me to tell me he has a settlement offer on your medical malpractice case. They are offering $3 million, but that offer is only valid for the next 48 hours. Can the defense attorney put a time limit on their offer? You want to know the answer? Come join me on this walk through the neighborhood, which happens to be in St. Martin today, as I share with you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, I'm shooting video today in St. Martin. We are on a deserted island. It's a beautiful little place here. It is 5 minutes walk across the water from a place called Coralita Beach on the French side of St. Martin. So now we're here because my wife loves picking seashells, and I have a few minutes to share this great information with you, so I brought my video equipment and I thought I'd share it with you. Okay, so now here's the question. You brought a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. Your doctor denies your allegations. Your lawsuit goes through the entire litigation process. In fact, it's now been 2 entire years since you started your case. The defense has refused to accept responsibility for what happened here. But now we are approaching trial. It's only a month away from trial. Each attorney is now getting ready and preparing for trial, getting trial exhibits ready, preparing witnesses, speaking to our experts. The defense attorney calls me and says, listen, I just want to let you know we have a settlement offer. We've conferenced the case with our principals. We believe the case should be settled, and I have an offer for you of $3 million. In this scenario that I'm describing, let's say the demand was $3.5 million. And now the defense attorney comes back to us and says, yes, we will agree to give you $3 million, but there's a condition. What's the condition? This offer is only valid for the next 48 hours. So by the close of business on Friday, if you and your client do not accept that offer, the money is being withdrawn and this offer is being withdrawn. Can the defense attorney put a time limit on their offer? And the answer is yes, he can. He can put lots of conditions in his offer. He can now say, hey, listen, I will offer you this money, but your client has to meet the following things. And if we're agreeable to it, fine, the case will be settled and done with. If you don't agree, fine, now we go to trial and a jury will reach a decision. But the more important question is it a good strategy for the defense attorney to go ahead and limit the time in which we have to go ahead and settle this case? I should tell you there's an inherent danger to putting a time limit on such a substantial settlement offer. The inherent danger is that I might not be able to reach my client in time. My client may be away. My client may be unavailable. For all I know, my client might be in the hospital undergoing certain treatment and I can't reach my client. In that instance, I'll have to call the defense attorney up, let him know I have not been able to contact my client, and can he please extend the offer for another few days? And if he's a reasonable person and he's professional, in all likelihood he'll say, of course. You don't know the exact reasons why this condition is there. All you know is you have a time limit, and now it's time sensitive. If you do not respond in that time, that settlement offer will be withdrawn. Now, what happens if I do reach my client? And now we have a discussion. We have a detailed discussion about the risks associated with accepting the offer and rejecting the offer. What do you mean there are risks associated with a substantial settlement offer? One of the risks is that you accept an offer knowing in the back of your mind that if you go to trial, there's a very good likelihood that the jury is going to give you substantially more money than what the defense is currently offering. So that is an unknown risk, and you won't know the answer to that until you reject the offer and go all the way to verdict. So that's an inherent unknown risk. You don't know what's behind door number 2. Behind door number 1, they just opened up and revealed, hey, here's $3 million. So now let's think about the defense's strategy. We made a demand of $3.5 million. They came back with an offer of $3 million. Clearly, they recognize they have liability here, that they have exposure, that there is the potential that if this goes to verdict, a jury will come back and give you a substantial amount of money. So now they're willing to give you a substantial amount of money as a guaranteed form of payment. And now will limit their risk if you accept their offer. Why? Because this way they don't have to go through the unknown of what's behind door number 2 and have a jury give a decision about what this case is worth. So they're doing it for selfish reasons to limit their risk. So we always have to talk about the risks and the benefits and any alternatives that might be available in this scenario. Will you accept this offer? The answer is it depends. After having a detailed conversation, we have to assess your risk for gambling, because now you have a significant amount of money in your hand or potentially in your hand. And if you decide to gamble, what happens then? You're now throwing the dice hoping that you get a substantially higher verdict. On the other hand, you could lose it all. The jury could come back and say, no, the doctor did nothing wrong and you get nothing. That is a possibility. And you know what? A lot of injured patients don't accept that reality. They don't accept the possibility that they could get absolutely nothing and their case gets thrown out. And so now when I begin to explain this, like, holy cow, you mean I could lose all this? The answer is yes, it is possible. It's possible that also the jury could give you a verdict in your favor and you get much less than what's being offered. Alternatively, you could get much more. But if you do get much more, there is the great possibility that the defense will turn around and now appeal. And that could bog things down for a couple of years and you don't know what the outcome is going to be. So why do I share this quick information with you? I wanted to share it with you because this is what really happens in these medical malpractice cases in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.